without support and precedent. I think absence of reason and logic. That's what I mean by extraordinary. There's my bias. And then I'd like to talk a little bit about the implications of the Medellin decision and where we really think we're going from here. So as to the reasoning, there are 3 points. First, the construction of the UN Charter. Second, the construction of the doctrine of self-execution. Third, the interpretation of presidential power. On the UN Charter, I have to say there were 2 oddities that I was struck with. The first is the pure textual interpretation, and that is the construal of the phrase that appears in 94.1 of undertakes to comply. As anyone looking into Mr. Webster will confirm, undertake is by no means equivocal. It just means to take on an obligation to comply. But the interpretation is that undertakes requires an additional step, that it is merely a commitment by the UN member to comply. It is not the end in of itself. But there's something more that was done with that textual interpretation, and that is that phrase, undertakes to comply, is not on its face a directive to domestic courts. That instead it's a directive to the political branches. I myself cannot see in Article 94.1 where we get from undertakes to comply to an affirmative bar from the courts of the United States who are obliged to tell us what the law is from acting. The second remarkable thing or oddity is the construction of 94.2, which, as you know, allows a party in the event of noncompliance to go to the Security Council. Now, the majority reasoned that because there was an existence of an international law mechanism in the event of noncompliance, that meant, and I quote, that it's a non-judicial remedy. It's self-evidence that ICJ judgments were not meant to be enforceable in domestic courts. Now, I hope I make an obvious point when I say that I don't think that logically there's any relationship between the availability of an international mechanism in the event of noncompliance to how we, the United States as a country, implement our international obligations. One has nothing to do with the other, and the ability of, say, Mexico to go to the Security Council does not in any way prohibit the United States acting under its own constitution to comply with the judgment. I want to move on now to the doctrine of self-execution, which has been hopelessly confused for those who have been watching the evolution of this doctrine for many, many years. And this was really an opportunity to, I think, clear that up. But I would say that it's an opportunity missed. The first point, self-execution means a lot of things to a lot of people, and it has been used to speak to whether there's a private right of action, for instance, under treaties. And in fact, some of the case law cited by the majority focuses on that question. But that is very different from the question of whether a treaty confers judicially enforceable rights in individual cases. And in fact, there's no better evidence of that than in Medellin, there was no dispute whatsoever as to whether there was a private right of action. We had the habeas statute. The dispute was only about whether there were judicially enforceable rights. I want to spend a little bit of time on the notion there's a presumption against self-execution. Again, if you look at the line of cases, the head money cases, Percheman, Rauscher, Asakura, there is no such presumption against self-execution. And in fact, the majority of the members of the court, including Justice Stevens in his concurrence, confirmed there is no such thing as a presumption against self-execution. That is not the rationale of the Justice Roberts' opinion, but if you look separately at Justice Stevens' concurring opinion, he agreed with the dissent in the principle that there is no such presumption. And I think that it is striking that the majority's reasoning, I submit, looked to the wrong place. It was looking to the text of the treaty to tell the United States as to whether or not and how it should enforce its domestic obligation. I think it's not a remarkable thing to say that multilateral treaties that are directed, and in this case the UN Charter, to 192 member states would not presume to include in it any magic language about what branch of the government it was directed at, because it simply couldn't, given the wide diversity of legal systems that are at issue in those 192 member states. And yet, a reasoning by which you look to either the text of the treaty or to congressional statements specifically about self-execution, I think really doesn't get you anywhere. And in fact, if you look at the other cases, again, Culverat, Asakura, a long line of cases by the Supreme Court, particularly early in the history of the Republic, you'll see that there was no such magic language in the other treaties that were automatically domestically enforced. And institutionally, I think that the Supreme Court's majority decision really reads the supremacy out of the supremacy clause, if you will. The supremacy clause is crystal clear, and it really was not the subject of any deep analysis in the opinion. But it is clear about the supremacy of treaties over judges of every state bound thereby. There is a textual, originalist approach that I think was crystal clear, but it is not something that got any time in the majority's decision. And the status of the Supremacy Clause cases and the 200 years of precedent that preceded Medellin, I think really is put in question by the reasoning on a treaty case as to the self-execution that avoids the central constitutional provision that would govern. And again, institutionally, in an attempt perhaps to articulate a means to escape the mandatory nature of the Avena judgment, and having been an oral argument, no court likes to be told that it has no wiggle room in terms of complying with another judgment. But in undertaking this analysis that says that we, the Supreme Court, don't have to apply this decision, I think ironically has undermined the Supreme Court's role and proper role in being the final arbiter of federal law, including treaties, telling us what the law is when it comes to federal rights, and implementing those rights when appropriate in U.S. courts. I think that is something that is a significant institutional point and a significant implication of the Medellin decision. I want to move on briefly to the presidential power. And here we had the unique situation where you have a foreign national on death row in Texas aligned with the President of the United States when it comes to attempts to enforce rights to process in Texas courts. At the time of the presidential determination, there were various news clippings in which Texas officials were quoted as saying that President Bush had been up north too long, and that he was losing touch with the reality of Texas and the state sovereignty issues. I think that what the Supreme Court did say on presidential power, which actually wasn't much, was expansive. And I quote, Supreme Court found that when the president asserts the power to enforce a non-self-executing treaty by unilaterally creating domestic law, he acts in conflict with the implicit understanding of the ratifying Senate. I think, however, that that's the standard for judging congressional acquiescence under the Youngstown framework, which was already discussed, is unprecedented in the Medellin decision, because effectively the majority construed congressional silence as presumed opposition. And I think that's the first time in applying the Youngstown framework to presidential power that you see the court going so far in that direction. And it could be a result of the fact, and you see in these line of cases, that this court is not a fan of presidential power. But I submit that a president acting in compliance with a clear international obligation imposed by treaty, that is a very appropriate and in fact modest exercise of presidential power. I move now to the implications of the Medellin decision, and I'll start with the parties in particular. Since the issuance of Avena, at least 33 of the 51 Mexican nationals named in the court's judgment have sought review and reconsideration in U.S. state and federal courts. To date, only one, Mr. Torres, has received review and reconsideration in Oklahoma State Court. I should mention that the state of Arkansas also agreed to reduce the death sentence of an additional Mexican national subject to Avena to life imprisonment in exchange for his waiver of the ability to pursue review and reconsideration. So that's two. All other efforts to enforce the Avena judgment have failed. And the Texas AG, since the issuance of the Medellin